Before we begin, we'd like to give special thanks to all of our sponsors for making this event possible each year. Specifically, thank you to CRL FormFox for being our title sponsor for 6 consecutive years. And thank you to our platinum sponsors, Psychmedics, OraSure Technologies, Quest Diagnostics, and Veriforce. Hello, and thank you so much for joining us for another Day with DISA session. Today, we're focused on a session, Do This, Not That, tackling the toughest employment issues during tough times. And we're joined by Joe Beachboard, Concierge Employment Attorney at Beachboard Consulting Group. Joe, how are you today?
Hey, I'm doing great, Thomas.
Well, hey, before we jump into the presentation, I want to remind everyone that if you have questions, use the Q&A button at the bottom right of the player. Any questions we're unable to answer today, we will reach back out to you after Day with DISA. Additionally, we'll make a copy of this presentation available for download in the Materials tab at the bottom right at the end of the session. With that being said, Joe, take it away.
Thank you, Thomas. Welcome, everyone. It's a real pleasure to be participating for the first time for me in the Day with DISA. I have the pleasure of discussing with you 3 of what I consider to be the toughest employment issues during what are certainly some of the toughest time. And I call this talk, Do This, Not That. My name is Joe Beachboard, as Thomas already referenced, and of course I'm from California. With a name like Beachboard, where else would you be from? Specifically, I'm in Los Angeles, and I've been a management side employment lawyer for 35 years. Last year, I ventured out of the world of big law firms to create my own, what I call concierge employment law practice. Much like concierge medicine, the concept is to give focused attention to a limited number of clients, partnering with them to achieve the best results for their companies and their employees as well. All right, so let's dive into this concept of do this, not that. And our first topic is remote work. And it's really hard to think of any employment-related topic that is much more in the news than this. The pros and cons of remote work are being regularly debated by not just the media, but also by employers and their employees alike. So what I want to do is talk about 3 different principles associated with remote work. And the first thing I think it's important to understand is that employees are watching how their employers respond to the experience of the pandemic. So I think the first tip is don't ignore the remote work issue. Now, there are many different approaches, and there aren't any real legally right or wrong decisions. You have to decide what's right for your organization and communicate that to your workers. Just don't drift and wait to see how it all turns out down the road. I believe that kind of uncertainty creates worker anxiety, and that anxiety will oftentimes lead them to look for alternative employment. Second, as you make your decision on how to handle this remote work issue, do consider the impact on culture. I don't think anyone can challenge that we are in the midst of a battle for talent. Understanding that and who you want to attract to your workplace and retain in your labor pool is critical. And that directly ties into your culture. So is having people together, interacting with each other, a critical part of your culture? And perhaps maybe even your business model? Or do you prefer to allow more worker flexibility? Whichever it is, you will want to make that clear and then lean into that with your employees. Third, when you evaluate your remote work strategy, as I like to say, don't assume that your employees are where you left them. Many of them have moved to a different city, state, or sometimes country. This leads to the question of whether you're going to retain or replace those employees that aren't where you left them. And if you retain them, you need to be prepared to deal with the issues of being a multi-state employer or perhaps even being a cross-border employer. For many of you, that's been your mode of operation for many years, and you're prepared to deal with it. For many others, this involves a complicated series of employment, tax, and possibly international law issues. Well, it's that time of year again, time to take stock of all the new laws and court rulings and how those affect our policies and thereby our handbooks. This is our second tough employment issue. Here are a few do's and don'ts regarding handbooks and policies for 2024. It's important that you don't invest all the time and often money into crafting and distributing your handbook and your policies only to let them sit on a shelf. This is a far too common mistake. Your handbook should be the standard by which you manage the employee relations functions at your organizations. Your policy should reflect your ideals, your vision, your culture, and they should be integrated into your day-to-day management. This includes things like, for instance, training. When I do training for a company, I always ask for the relevant policies and I integrate them into the session. Not only is it important for employees to understand the company's policies and expectations, it is critical that we demonstrate the handbook's relevance by regularly referencing it. Second point, do make sure your handbook is accurate and up to date. This does require an annual review. Now, I know that's a pain in the butt, but it is critical to make sure that your handbook reflects the true and current situation at your organization. And of course, the laws are changing so fast in many parts of the country and even at the federal level that an annual review is critical to ensure that your handbook is legally accurate. Tying into legality is our third point. Do evaluate the multi-jurisdictional issue. With the development of more and more state employment-related laws, this has become a much bigger issue. So if you are based in a state that has relatively few employment laws, let's say Nevada, but you have employees in a state that has many such laws, let's say California, you have to decide how to handle that issue. I'm sure many of you have faced this issue already, but let's review some of the options. I've seen some companies just draft their handbook consistent with, in our example, let's say Nevada law, and they commit that they will remember the unique aspects of California law that they need to apply to their workers there. This can be a dangerous approach, both because it can be difficult to remember all the unique laws in a state like California, and because you are technically providing employees in California with information that is inaccurate under the laws of their state. Now, of course, you can put qualifying language at the beginning of the handbook that states these policies apply unless they are inconsistent with state or local laws, but this only goes so far in protecting you. Now, I've seen other companies draft their handbook consistent with the law in the state in which they have employees that has the most employee-friendly employment laws. This is what we call the most favored nation approach. This has the advantage of allowing you to treat employees consistently, but results in you extending more rights to employees than might be the case under their state law. Then there's the handbook supplement approach, where the basic company policies are supplemented by local laws for those employees in those other states. Now, sometimes these additional or revised policies are included in the handbook itself, but that's not so great for the morale of the employees who are not receiving the additional rights or benefits reflected in that supplemental part of the handbook. Of course, you could also create a separate additional handbook for those in states with significantly different rights and or benefits, but effectively then you end up with two handbooks. Well, and then finally, there is what I refer to as the just screw it approach. Some multi-jurisdictional companies have concluded that the juice just isn't worth the squeeze. And so they've decided not to have an employee handbook at all. Now, some of these organizations will, on the other hand, develop a policy book for supervisors to use in managing their employees. For some, this can be an effective, but is certainly a non-traditional approach, and it also brings with it some obligations to make sure that you distribute certain important and oftentimes legally required information to your employees in another format, since you don't have the handbook. What's the right approach for you is really an individual business decision. But I do recommend that you consult your legal counsel and you have them assist you with implementing whichever approach that you choose to take. All right. Our third and final tough topic is severance agreements. You know, I'm finding that more and more employers are willing and interested in entering into severance agreements with their terminated employees. Of course, the advantage is they obtain the benefits of a release. Also, these can help many HR professionals sleep a little better at night. And there's some advantages to that as well. But here are some thoughts on severance agreements and releases. First of all, don't assume that a severance agreement that you find on the internet is adequate. This is a very dynamic area of the law. You want to make sure that if you're going to pay someone a nice chunk of change for a release, you want to make sure that the agreement is enforceable and that it provides the company the most protection possible. This is well worth the investment of getting the assistance of your labor counsel. Second point, do consider the state where the employee works. There are radically different requirements depending on the state at issue. In California, where I am, for instance, there are multiple provisions that we include here that you wouldn't have in your agreements anywhere else. It's important to make sure that you and your counsel tailor the agreement to the law of the state in which the individual resides. That's the law that's going to apply, no matter what your handbook says might be the state that applies. So keep that in mind, a very important point and a common mistake. Third, do consider the age of the individual signing the agreement. Remember, there are significantly enhanced protections and requirements for employees over 40. To obtain a release from these individuals, you must provide them with certain specific notices. You must give them 21 days to evaluate the release, and you must provide them 7 more days to revoke the agreement. Don't make the mistake of paying someone the severance benefits until that revocation period has expired. If the individual revokes after receiving the benefits of the agreement, it is oftentimes very difficult to recover them. Third, do consider whether the employee is non-exempt. Now, historically, severance agreements have been used for primarily exempt employees. But with the growing popularity of severance agreements, we're seeing more non-exempt employees being offered them as well. What you need to remember is that these individuals, non-exempt employees, are covered under the National Labor Relations Act. And the General Counsel of the National Labor Relations Board, which enforces this statute, has asserted that you can't include certain language in severance agreements that are offered to non-exempt employees. These include common provisions such as confidentiality provisions, non-disparagement agreements, non-solicitation agreements, and non-compete clauses. Don't make the common mistake that the National Labor Relations Act only applies to employers with unions. It covers all employees who engage in any form of protected concerted activity. Fifth and final, I guess, do get legal advice. As I hope is clear from the above, this is a complicated area, more so than many even experienced HR professionals recognize. There are a lot of factors that can affect the ultimate language used in any particular situation. For some of my clients, for instance, I have drafted templates that they can use. For one employer, that has resulted in 8 different versions of the severance agreement, and that's just in California. So I asked them to give me the opportunity to review that document before it is presented to the employee so that I can confirm that it's the right terms for the right employee in the right state. And I even just usually do that for some fixed fee amount to avoid the financial disincentive of using counsel. A mistake here can not only limit your protection, but actually end up in you paying a lot of money to a departing employee and then still facing an expensive lawsuit from either him or her. So make the investment in legal counsel and get them to review your severance agreement, make sure it has all the right provisions and that it's right for the state that that employee resides in. So that kind of concludes our 3 tough employment law topics for tough times, but I know this is an area that can generate a lot of questions.
Awesome. Yeah, and it certainly has, Joe. So thank you so much for being here today. We'll kind of tackle those real quick here. How does a primarily remote workforce change my legal risk?
Well, Thomas, that's an interesting question. I mean, I think one of the things that we've learned in this post-pandemic environment is that it's different when we have employees remotely. There are different issues and there are different risks. I think, 3 of the biggest risks that pop right to mind are first of all, wage and hour issues, because it's just harder to track time when employees are working at home. They don't show up, clock in, and then clock out, right? It's different. We have to encourage them to actually, start the time, end the time, that they don't work without writing time down, maybe later in the evenings, earlier in the mornings. It's just challenging from a wage and hour issue. There are also some challenges from a workplace safety issue, right? We don't have that opportunity to ensure that everything is safe and secure in everybody's home, where we can do so, of course, when it's in a particular work environment. And then I think the interaction issues are different, right? And those interaction issues can drive discrimination claims, harassment claims, retaliation claims, those kinds and types of things. They don't disappear when people are remote, just because people are interacting in a different platform, if you will. Doesn't change those risks, but it changes how we address them. And it changes in some ways how we have to train our employees to how they utilize those tools and that they utilize them in a way that don't offend the people that they work with.
Yeah. Another question, are there states that I should avoid hiring remotely in?
Well, most folks would tell you avoid California, but I'm not going to tell you that because I'm in California and, we still want employers to be here despite what the legislature may do up in Sacramento. It may not seem like that, but there are states that have greater challenges. Now, oftentimes they're also very economically successful states. And so they're states that a lot of employers want to be in. States like New York, New Jersey, Florida, Michigan, California, Oregon, Washington are all states that do have more progressive employment-related laws, progressive from the employee standpoint. But what I will tell you in any of these states, and again, I've been doing this for 35 years here in California, is that shouldn't drive your employment decision, or that shouldn't drive your hiring decision if you have a really talented individual. These are eminently manageable issues. They take a little time and they come with a little risk, but usually you can minimize that risk by just making sure you're educated on the law and making sure you have some help applying that law to that particular individual in that particular state.
Got it. What's the next big policy or practice issue that you see coming down the road?
Well, what I would say is, and it's already started, it's the issue of what we call restrictive covenants. So these are agreements that we have employees sign either as part of the employment process or maybe included in a severance agreement, like we talked about a minute ago, that says that employees can't do certain things after they leave our employment. That could be something like a non-compete clause. It could be something like a non-solicitation clause. Those are both examples of what we call restrictive covenants. Some states, like here in California, have already prohibited the use of some of those agreements, like non-competes, and even non-solicits are very disfavored. There's a number of federal agencies like the National Labor Relations Board. We talked about them a minute or two ago, and the FTC that are both saying they're going to focus on non-compete provisions, and with the goal of making those illegal, which would of course make them illegal nationally if they were able to do that. So I think those are provisions that a lot of employers use in a lot of states and rely on, that I think in the next 3 to 5 years, it's going to be a lot more difficult to do so if the current trends continue.
Gotcha. How often should we review our policies internally? How about externally?
Well, I think externally once a year is good. And I think having a legal counsel review it once a year, I think is probably acceptable. I think internally, I think it should be done at least twice a year, just a kind of a check-in to see, both from a cultural standpoint and a legal standpoint, is there anything that's changed that we need to address in our handbook or with respect to our policies and procedures? Of course, at times there'll be big changes in the law that require an immediate response, but usually those will get so much attention we know about them. So in terms of regular, once a year external, twice a year internal.
Great. Which laws do I follow when an employee works in one state but lives in the other?
Yeah, well, it comes down to what that means by works, right? So if they work in the state in which they reside, which is usually the case, then it's going to be the state in which they reside, because that's where they work. Now, you have some employers that maybe the employee lives in Washington and works in Oregon or something like that, where you can cross the border. In those cases, it's going to be the state where they perform the work. But in this remote environment, a lot of employers think, well, we're based in Nevada, so we're going to apply Nevada law even to California employees. Well, it doesn't work that way. The states say that the law that governs individuals who are working within their state is their state law, not necessarily the state law of where the employer is located or where their handbook may say is the law that they're going to apply. It's the state in which they reside, and that's an important, and if that's where they also perform the work. So it's important that we make that very, very clear.
Another question on policies you had talked about is the juice worth the squeeze. How big is the risk of policies not being up to date or being followed inaccurately?
Well, Thomas, the big issue is really at the end of the day how you apply the policy, right? I mean, there are certain disclosure obligations that we have with respect to employees in particular states and under federal law as well. But really, when you generate a legal risk situation, it's when you apply what your policies are to your particular employees. And I think that's one of the reasons why some employers have said, well, what we're going to focus on is really kind of a policy guidebook for managers and supervisors that tells them how to handle particular situations and maybe educates them in a little more detail on the laws that apply to the situations that they may be handling. And we're not going to worry about these employee handbooks things. Now, let me say, Thomas, that I think there is a role and I think there is a value to handbooks. So I think companies should have handbooks. I like there to be policy guides too. So I think, having both is perhaps the most effective strategy. But if you don't have some sort of direction out there, whether that's encompassed in your employee handbook or in a policy guidebook or both, then there's almost like there's no rules. And I think in that environment, then people just kind of defer to whatever they think the rules are or what they think they should be. And it also makes it look like the company isn't very well organized in the sense of how it is dealing with these workplace issues. So you have to incorporate all of that into your decision as to whether or not you think the juice is worth the squeeze.
Awesome. Appreciate the answer. What are the biggest things that I should be sticking to when negotiating severance agreements with, now ex-employees and their releases?
Yeah, well, here's what I will say, Thomas, is there's kind of three areas that I see. And of course, I represent management, so I'm usually dealing with what are the primary sticking points, if you will, from the employees or oftentimes their counsel as well. I think there's really three big issues to keep in mind that they're going to come back on. One, it's going to be money, right? It's going to start with that. So you have to sort of factor in, okay, if I'm willing to pay a 3-month severance to get a release, all right, what am I going to offer to start? Because they're going to counter and then we have to counter. And then, so if that's where I want to end up, you have to keep that in mind. Of course, they're keeping that in mind as well. So money is the first key thing. Oftentimes I see there being a lot of questions about reference language, specifically what's going to be said to any prospective employers. Obviously, that individual is going to be out looking for a new job, and they want to make sure that they're going to get the proper kind of reference, or at least what they're willing to agree to be the proper kind of reference. And then I guess the third area that I would probably see is non-disparagement agreements. And companies really like to have agreements in there that former employees won't be saying bad things about them. But every time an employee sees that, they say, whoa, wait a minute, I want that kind of same agreement. I want them to say they won't say bad things about me. And that makes it what we call a mutual non-disparagement agreement. The problem that we have, though, is it's very hard for an employer to represent that everybody in this company won't say anything bad about this former employee. You really can't make that representation. And so what we usually end up doing in those circumstances is negotiating with the employee, like, okay, give us the 5 people that you're most worried about them saying something bad about you. And then we will agree that we will tell them, please don't say anything bad about that particular individual. That usually resolves the issue and allows us to get a completed severance agreement.
No, that's a good way around that for sure. What actions can I take if an employee refuses to sign a release?
Well, there's not a lot. I mean, what you're asking an employee to do is waive their rights to sue, and you're trying to convince them to do that with financial considerations or other considerations like, extended employee benefits or something like that. And if they choose not to do that, there's almost nothing you can do to force them to sign a severance agreement. If you do try to force them, then you're engaging in what the law calls duress. And if you engage in that duress, they can actually come back and overturn the agreement and the court can find that the agreement's unenforceable because you tried to force them into signing an agreement and that they didn't really want to waive their rights.
Got it. Can I put conditions or delayed payouts on severance packages?
Sure. I mean, when the employment relationship ends, depending on the states, you have to pay them everything that they're entitled to at that time. So any earned compensation, say in a state like California, you have to pay them all of the compensation they earned on their last day of work or shortly thereafter. This would include accrued vacation that they're entitled to as well. And it varies a little bit from state to state when you have to pay or if you even have to pay for vacation. But normally you pay them all of the compensation they've earned within a short period of time of their final day. If, with respect to, however, the consideration that you're offering them, let's say, you're offering them 6 weeks of pay or 6 months of COBRA benefits or whatever the case may be, you can pretty much structure that however you want. Sometimes employers find it advantageous to structure those payments as basically salary continuation. I mean, it's not really salary continuation because they're not employees anymore. But what a lot of times employers like is the fact that while they're paying that out over some specific period of time, especially if the period is a longer period of time, like let's say 6 months of severance or something like that, they would like to ensure that that employee is abiding by, well, for instance, the non-disparagement provision we just talked about. And so you have some leverage over them if you're paying it out over time. But of course, employees want it all in a lump sum.
Got it. Can't I just have all of my employees sign NDAs when I hire them instead of paying severances?
Well, so, NDAs serve a very different purpose than a severance agreement does. Now, non-disclosure or confidentiality provisions can be incorporated into a severance agreement. But normally the value of a severance agreement for any particular employer is a release regarding any employment-related claims. And of course, an NDA is simply going to say that you agree not to disclose information that you acquire while you're at that particular company. And again, those provisions are oftentimes included in a severance agreement as well. But the real value in most cases is the fact that once you get a signed severance agreement from a particular employee, you know you're not going to get an EEOC charge. You're not going to get you're not going to get an OSHA complaint. You're not going to get a wrongful termination, discrimination, retaliation lawsuit from that individual. And those just simply aren't covered under most NDAs.
Gotcha. I know we're tight on time. One last question. Should lawyers review each individual severance, or can I have them review by state?
I think that you can create templates, right? I think, you can have, when you look at your severance agreement, you can have your template for California and your template for Nevada, in our example, for instance. You can have a template for over 40, under 40 in California, over 40, under 40 in Nevada, right? So I think you can create those templates. And I think HR people can definitely manage those. Now, again, I always recommend that you have your lawyers just give one last quick look to make, a second set of eyes on something as important as a severance agreement with all the legal provisions that are in there. It's worth the value of a half hour of lawyers' time to make sure you're giving them the right agreement, especially if you're paying them a significant amount of money.
Great. Joe, thank you so much for your time and your insights today. Again, appreciate you being here.
Thomas, it's truly been my pleasure. I really appreciate the opportunity to talk to everyone, and I hope they enjoy the rest of the conference.
Yeah, and I just want to say thank you to all of the attendees for participating in this year's Day with DISA. We're truly excited to be able to share this thought leadership with you. Thank you so much. Goodbye.